SJC-12560, Commonwealth v. Stanley, Williams.
May it please the court once
You
again.
look a lot like the last guy.
I feel like the last guy, just a little better prepared this time. May it please the court, and good morning, Justice Lank as well. I'm Merritt Schnipper, this time on behalf of Stanley Williams. The law of this Commonwealth has always been that a person who uses force in justified self-defense is not guilty of any crime. And if you're not guilty of any crime, you are factually innocent, both in any common understanding of the term and for purposes of Chapter 278A. Now, the Commonwealth suggests that a person who acts in self-defense has not asserted factual innocence because they're still guilty of an offense, I put that in air quotes, against either some sort of code of social behavior or basic concepts of morality. You've caused a harm. I would just take serious dispute with that concept. In my reply brief, I excerpted a long quote from William Blackstone, really just to show the long-term understanding that a person who's actually set upon in the street and attacked, as is basically what Mr. Williams alleges in his affidavit of innocence, and fights back successfully, and with the result that his or her attacker is harmed or killed, has not committed any offense. And
I don't mean to preach to the choir, but if you acted in self-defense, then you didn't commit a crime.
Then you're entitled to move under the statute.
I
Yeah.
fail to understand the other side of that
Hey,
argument.
Can I then
Comment.
probe, just back to Justice Gaziano's question from the last case? So if someone's convicted of first-degree murder,
Right.
but they have a potential excessive force in self-defense to drop this, is that covered by this statute or not?
If there's forensic evidence that would support the claim that they acted in justified self-defense but then used excessive force, say, I would say that that is covered under the statute because they've been convicted of a statutory crime.
There's no possibility of an innocence verdict, but there is an excessive force in self-defense. We still have forensic testing here?
I think, well, again, the materiality argument has to be made under Section 3B4 and then the corresponding part of Section 7 by the preponderance, and that's the burden on the claimant to show, to explain in the particular case. But just to refer to our case, the affidavit that I submitted from the firearms expert, he says, here's what Mr. Williams alleges, and if I test this clothing and I look at the powder burns and the powder residue, I could potentially tell you whether, as he argues, these shots were discharged while the two men were grappled in combat fighting for a gun, or whether, as the Commonwealth alleges, he fired once at close range and then stepped back 4 or 5 feet and fired a second shot.
So,
and that really is the difference between innocence here and manslaughter.
So under your view, the best you can get is of course, they're not guilty because it was proper use of self-defense, but because it's working out there always, the excessive use of self-defense, that doesn't mean it's not a complete defense, right?
Right. Well, I mean, here, this is a manslaughter conviction. So here it is a complete defense. Excessive force in self-defense, I agree there's an issue. I mean, I see the issue you're identifying.
I was just talking about the hypothetical that Justice
Sure.
Kafka had
You've still been properly convicted of
Yeah, so
a
let's
crime.
go to his hypothetical, not this case. So
Sure.
person's charged with murder. The person says, if you test for gunshot residue, you're going to find one gun. It's proper self-defense, not guilty.
Right.
Government says, well, it still could be a manslaughter. You say that doesn't matter because I'm asserting factual innocence because of the not guilty.
Sure. So there we have the potential, the language in the statute that says the potential. So at first, I'd say you definitely clear the Section 3 hurdle with the allegation and the hypothetical. And Section 7, you would then have to get to testimony by the preponderance of the evidence to show whether that claim, but let's say that the evidence showed by the preponderance of the evidence that you could have asserted an imperfect self-defense claim and that you were thus improperly convicted of murder, but you still could theoretically have been, because, right, we can't find a new conviction at this stage or even at the Rule 30 stage, you'd have to go to the second trial. So unless, I think you would be struggling to make your showing under Section 7 if the best you could do with your testing was to show you had imperfect self-defense. But if your evidence had the potential to show that you acted in complete self-defense, but it also might end up showing you acted in perfect self-defense, well, then you would have an argument under Section 7, and that's really where you get to the preponderance standard and a judicial discretion to make those rulings.
Because going back to the last question I asked in the last case, and this is probably more appropriate for this case, is if we look at the broad definition of factual innocence, the person did not commit the crime that they're presently serving a prison sentence for.
Right.
You're not saying that if if there's evidence that would produce, if there's forensic testing that would produce evidence of a lesser included offense, is that included or not?
I mean, my instinct tells me, I think it's going to have to be case-specific, but it's harder to see that. To say, oh, I could get to a lesser included offense only, I couldn't actually prove that I'd be entitled to an acquittal, because then you're kind of into the legal innocence zone, right? But when we talk about legal versus factual innocence, I think it's very important to realize that these are very, like, so Justice Gantz in the last argument was talking about, oh, I had a motion to suppress, and if that had been granted, then this evidence would have been sufficient, and I would have been acquitted. Well, that is a purely claim, obviously a legal innocence claim, right? I mean, that the U.S. Supreme Court has said, basically the difference between factual innocence and legal innocence is factual innocence is assessed with all probative evidence in play, including the newly produced evidence that's the basis of your factual innocence claim. Legal innocence is really more about whether you are entitled to acquittal under applicable procedural rules, which of course could be the exclusionary rule, testimonial rules, all sorts of stuff like that. So the first question is, do you have a physical piece of evidence that could potentially contribute to that inquiry? Right here we do. We have sweatshirts and we have discharged firearm cartridges, both of which could be tested and could be found to be associated with the man who was killed here, rather than my client, Mr. Williams, who says he was attacked and fought back in self-defense, right? Then we have to ask ourselves, if the testing that we obtained actually showed what we're hoping it will show, or we think it may show, and we brought forward that evidence, would that then be the type of evidence under which a reasonable jury could do nothing but acquit, right? And that's really where the rubber meets the road in terms of materiality. You really have to get to that point of thinking about what does this have the potential to do, and how does the evidence it could potentially produce interact with the theory of innocence that's being advanced by the defendant, and that's how you really assess materiality. So, and the reason in both these cases that I felt it necessary to submit arguments and affidavits that put more details of the defendant's version of the offense conduct or the alleged offense conduct before the court is that it's incumbent on each claimant to satisfy materiality. And if you say I was walking down the street and they said I looked like a guy who robbed a store, but it wasn't me, there's really nothing more to say, right? But if you say, well, I was walking down the street and I was attacked and we started punching and then this guy pulled out a gun and I dove and pushed it against him because I was afraid for my life, and all of a sudden the gun went off and he fell to the ground and I ran away, I mean, I think you really need to explain that innocence claim in order to make your showing under Section 3B4. I just think that we have done so because we've explained he's factually innocent under longstanding law. We've explained how the testing can support that claim, and if that claim were borne out, we would have a person who was wrongfully convicted because they hadn't committed a crime and yet they're incarcerated in state prison. I mean, so that's factual innocence, and we don't really, again, there's a big difference, I think, between when you want to test evidence that is the core of the crime or the core of the case, and when you want to test something that's collateral to the case. I mean, I think that is as useful a distinction for the court to draw. And I'll go back to the cigarette butts in Moffett, and I know there's a question of third-party perpetrators there, but, obviously you have homicide offenses. I mean, there's going to be a relatively significant number of those cases where there's not going to be any other witnesses around other than the defendant. So you're going to be looking for some objective evidence to try to help us understand what actually happened. And if the evidence that's being sought to be tested could actually help us understand what actually happened and get closer to the truth of the facts underlying the prosecution, I mean, that's what, a forensic, post-conviction forensic testing statute is all about. I mean,
But that's really Section 7, because, as you know, Moffett was Section 7.
Sure.
That limiting principle you're talking about is important, but it's a Section 7 limiting principle.
Sure. So in this case, which is, I think we all agree, this one is just a Section 3 motion. So this is a pleading standard. You basically just make your claim. And I think, the Commonwealth doesn't dispute that we satisfied everything else other than factual innocence and materiality here.
Correct me if I'm wrong, there's identification language, and I know there's a dispute, of course,
what it
to
means.
this case
Sure.
of what it means, in Section 3 as well, right?
Right, exactly. And that's where that's the pivot point for this case specifically, is that, the question of whether it's materiality to his identification as the perpetrator of the crime, because here nobody's
Because
contesting.
we have that in Section 3, we have that in Section 7, and we have a definition of it in Section 1.
Right, and I think it's really important, maybe even more important for this case than it is for Mr. Putnam's case, that the definition of identity in Section 1 is really, really important, because it's not about saying who is the man who fought with the victim here. It's saying whether that man who fought with the victim was correctly identified as the person who perpetrated a crime.
And Ms. Snipper, when we line up those three different sections, 1, 3, and 7, in the identification of the perpetrator language, is there any difference?
No, there's not a meaningful
Okay,
difference. I mean, so basically what you're saying, when you have, just let me focus on section 3, since that is what my motion is under, you're saying, is it material to identification as the perpetrator in the underlying case? You're really saying, so what you're saying, it's not.
I didn't really see a difference between the three of them.
No, they're the same.
Okay.
And none of them have to do with identifying an individual by his or her distinguishing traits, his name, social security number, fingerprints, whatever. It's Mr. Wade. Everybody knew he was the one at the house with the victim.
But
right?
Wade said I didn't do it.
Right. Well, so does Stanley Williams. He says, I didn't do it because I didn't commit a crime because I was walking down the street minding my own business and I was attacked by a gun-wielding man. So, I mean, you know, I don't think, it's not, as Justice Lowy says, it's really not plausible that that's not an innocence claim. And once we agree that it's an innocence claim, then we're into the territory of, well, is this evidence that we want to test relevant to helping prove or potentially disprove the innocence claim? And I think we abundantly satisfy that here because of the direct connection between the alleged offense and the testing.
Now, section 3, B and 7B4, if I have the subsections right, when they talk about identification, they don't use the term factual innocence. So that definition in section 1, which might seem to answer the question, doesn't necessarily answer the question because that definition is not part of the issue where we're talking about identification in section 3 and section 7B4. Can you comment on that?
Sure, I agree with you, it's not in there. But I do think, I mean, it's a longstanding rule of statutory construction. You don't take a tiny little subject and then read a limitation on the broad sweep of a statute from it unless that's the only way to do it that makes any sense. So what we have to think about is how does this materiality requirement interact with the fact that this is a statute intended to provide potential relief for people who say they didn't commit the crime for which they were convicted. So we go into it saying, okay, this claimant has properly moved under statute, you know, imprisoned, convicted, and says, I'm factually innocent of the offense. So now you are entitled to bring a motion. You have to bring a motion that satisfies the 5 factors of section 3, including subsection B4, which says it's material to your identification as the perpetrator, and identification itself is tied definitionally to the idea that you're the person who committed this offense. Right, so if you're not the person who committed this offense, well, you're then factually innocent under the definition that's set forth in section 1. So it really is incorporated there by spirit, although it's not saying, you were so like, for instance, the legislature could have said, and I wish they had, you know, that this is material to the factual innocence claim. But on the flip side, obviously, given the remedial purpose of the statute, and this court has previously said it needs to be interpreted in a generous manner, you know, it certainly doesn't say identifying an individual, you know, under the terms of their distinguishing features, making sure that we have the right person and not his or her twin brother or, you know, somebody who has the correct social security number. And we're not just talking about picking out an individual, we're talking about picking out an individual who committed a criminal offense. So if an individual didn't commit a criminal offense, we're really back to square one with a wrongfully convicted person and then trying to answer the question about whether the legislature said, well, yeah, that is a wrongfully convicted person, but we don't really think that's the kind of wrongfully convicted person we want to help here. I just don't see that kind of indication of legislative intent, especially given like sort of the penumbra of generous reading that we're entitled to here. And to answer Justice Kafker's question from last time about the legislative history, it's not particularly detailed. There is one specific case referred to where a woman was assaulted by a person she mistakenly thought was her former boyfriend. Turned out the former boyfriend was, you know, in another state or something at the time. That's kind of a mistaken identification case, but it's certainly not the traditional, hey, we got the wrong guy out of a lineup mistaken identification case. That's the only specific case that's referred to my recollection. But what's notable to me is that there's no mention in the legislative history of mistaken identifications, whether you want to talk about show-ups, lineups, or photos arrays. What there is talk about mostly about the barriers that claimants face accessing the initial layer of investigation of their innocence claim. And I think you really, while the legislature clearly intended to dissociate Section 278A from the functioning of the Rule 30 procedure, it's important to think about its relationship to an overall challenge to a conviction by thinking about what the Rule 30 procedure does require.
Can I ask you the same question, Justice Hall? We asked you in a different way.
Sure.
The way you read it, I think, and the way you want us to read it is the materiality, it has to be material to a claim of innocence. And you had said you wish the legislature had said that to be more clear.
Sure.
Along the lines of statutory construction and the use of superfluous language, what purpose does it serve to have in this section of the statute 3 provisions that all say material to the moving party's identity as a perpetrator of the crime? Why is that language there, in your view?
I think it's there because the legislature is focused on making sure that a person who committed an offense is the only person who's actually convicted of it. And if the legislature had put in the more widely reaching language that I had said I would like to have, I think you would then have a statute that allows people to seek forensic testing on collateral evidence. So if it would just said it's material to your factual innocence claim, well, then we're into maybe I could impeach the only witness who identified me by saying there's your fingerprints on a liquor bottle, and that means you probably didn't see me very well. I mean, that doesn't satisfy materiality as defined thus far by this court's decisions, but it would satisfy a material to the innocence claim because it would simply have some relevance to a claim of innocence. I think the way that the legislature chose to narrow it is to say, we want to make sure we're looking at that the correct person was arrested and prosecuted, and we want to make sure that the testing that they use to challenge that determination is evidence that has a direct nexus to the crime. It's not some sort of collateral kind of way out here evidence that only has a passing connection to the crime. And in this particular case, we're seeking to test the clothing worn by the alleged victim and the cartridge casings that were discharged from the firearm that killed him, both of which have a strong possibility of showing that, as Mr. Williams alleges, Mr. Owens is the person who brought the firearm to their conflagration and thus was the only person who sort of committed it.
Counsel, have you had occasion to look at any other states and their statutes along these lines, and if they're similar or not, or shed any light?
Sure, I do. I mean, I looked, but I have to credit the amicus for pointing the case to the Washington Court of Appeals decision in Bra, where there was a self-defense claim was found to meet their factual innocence statute, which also is nexus to identity. And then in the Putnam brief, I point the court to the People versus Shum case where there was a rape and murder where the person who survived said, it was this man, I know him, he's a friend of my boyfriend's. And so similar in that sense, there was no question of mistaken identification as is traditionally understood, but the defendant said, no, I know these people, but I didn't have anything to do with this crime. Now, that person didn't say I was there and I didn't have anything to do with it. He said I didn't have anything to do with it. But either way, he was not mistakenly identified. In other words, his accuser knew who they were intending to accuse.
What state was that, please?
That's from Illinois, the Shum case, and that's cited in the Putnam brief. And then in the amicus brief by New England Innocence Project, there's the Bra case, B-R-A-A,
Washington.
Washington Court of Appeals.
And does the Washington statute use that language, material to the identification?
It makes the motion needs to be relevant to identification. I can't recall if it uses the actual word material.
Does it use the word identification?
Yes, it does.
Okay.
Okay, thank you.
Thank you very much.
Mr. Shepherd-Brick.
May it please the court, David Shepherd-Brick on behalf of the Commonwealth. To answer the court's question, Justice Kafker, the Washington statute the defendant must explain why DNA evidence is material to the identity of the perpetrator of or accomplice to the crime. So it does detain that requirement. What it doesn't actually have is a requirement of factual innocence. And I would suggest that's the difference between this statute, which is, I would suggest the Massachusetts statute is much more comprehensive. It details all the requirements the defendant must meet. And I would suggest that the most important requirement here was not met, which is the defendant did not allege factual innocence. He alleged legal innocence. And that is in accord with both the 6th, 4th, 10th, and 11th circuits have all concluded under the Schlepp standard that a claim of justification or excuse are not a claim of factual innocence, but are a claim of legal innocence.
Well, let's cut through it. If somebody indeed committed a killing in self-defense and you convict him, do you view that to be a wrongful conviction?
If he truly acted in pure self-defense, absolutely. That is someone who is legally innocent of the crime of which they're convicted.
And factually innocent of the crime?
I would disagree with that because...
What's the crime? What's the crime?
The crime is still murder. It is just justified. And I think the court has always made that distinction particularly with, one, it has treated justification and excuse as synonymous. So we're dealing with everything from not guilty by reason of mental disease to pure and true self-defense. The court has said that those defenses negate malice, but that they include, as the court held in Bruno, two findings. One, that the defendant committed the criminal act, and two, that is entitled to an acquittal because the policy reasons for punishment are absent.
But you wouldn't feel badly if he had committed a criminal act. You wouldn't feel badly if he had committed a criminal act.
He wouldn't feel badly, or I wouldn't?
Wouldn't feel badly.
I certainly wouldn't feel bad in the sense that you're talking about. I think that I think as this court said a long time ago in York that the killing of another person is still it's one of those social wrongs. It's one of those basic wrongs of human nature.
But why is it wrong if you're killing in self-defense?
It is.
Consider those persons arguably to be at times heroic.
Because the wrong committed by the defendant is outweighed in the case of pure self-defense by the wrong committed by the victim. In essence, the victim's wrong has forced the defendant to make a difficult and presumptively unlawful choice. He has been forced into make a choice that we all intrinsically know, inherently know, is against our nature.
And in an arson case where the person claims a defense that the fire was accidental and was not set, is that legal innocence as opposed to factual innocence?
No, I would agree that is a claim of factual innocence.
So you're saying it is sufficient that the person committed the act?
Correct.
But the statute defines factual innocence as a person who did not commit the offense.
Correct. And when it says offense, it doesn't require that it be the criminal act. It simply, or it doesn't require that it be a punishable crime. It just says that it has to be the offense. Well,
it uses offense twice in the definition. A person convicted of a criminal offense who did not commit that offense, meaning the criminal offense of conviction. Correct?
I would agree with that in part. I think what the legislature was attempting to make out is that offense in the sense of they wanted to limit the statute. I mean, it's very clear from the legislative history that this was, and I would say I have reviewed all the legislative history. They did cite to, there's a movie, Conviction, which was discussed in the legislative history. It was about DNA evidence, someone who worked to have their brother exonerated using DNA evidence because the wrong person was convicted. He was not involved. And I think that's what the legislature was going about.
Focusing on that movie as opposed to the Australian movie about where the dingo killed the child as opposed to the
Dingo did do
parents?
it
The dingo did do it, or are you focused on the recent film in which Thurgood Marshall supposedly defends somebody for rape, in which it turns out, I hate to give away the end, but the woman it was a consensual act? Do we need to focus on which movie?
Well, let's focus on it. I mean, honestly, I don't understand this argument, but, and I don't mean this to be silly, but in Fatal Attraction, when Glenn Close gets killed, she committed murder, but it was justified? I just don't understand this argument. If you act in complete self-defense, you didn't commit a crime.
So wouldn't you be stand on better footing if the language was one who is factually innocent is one convicted of a criminal offense who did not commit the act for which he or she was convicted, because that distinguishes between whether the act was criminal or not, and that's just not what it says here.
I don't think that language is necessary, and the reason is because that, again, this court has treated justification and excuse as something that negates what is otherwise criminal. If justification, self-defense, is included, then excuse should be included. Not guilty by reason of mental disease should be included as a factual innocent claim, except this court has already said that it's not a factual innocent claim, because in Bruno, the court said that it requires a finding, that a not guilty by reason of mental disease includes a finding that the defendant committed the criminal act. They both negate malice. Justification and excuse both negate malice in murder. So I agree that the person is not to be held legally responsible if they truly if their conduct is excused or justified. But that's our legal system recognizing that the result we reach 99 times out of 100 just doesn't apply to this one case. Or the policy reasons that we have for that rule just don't make sense here. But that's a recognition by the legal system that what we know is wrong can sometimes be excused or justified. And I understand that there's some pushback on that, but I think when you read it together with the requirement of identity, the motion judge was entirely proper in denying this defendant's motion, because even if a claim of self-defense is a claim of factual innocence, it is not material to his identity as the perpetrator, because he does not dispute that he was the one who was there, who engaged in the act which caused the defendant's death. These cases, again, going back to legislative history, it was about, as Justice Gaziano said, whodunit cases. I mean, it's about cases where the wrong person was identified, and there are a number of legislators who talk about the statutory purpose.
So how do you distinguish between this and the last case where you had the issue being whether it was consensual? There's the act, which is either criminal or not criminal, depending on...
Right.
Right?
Right, but it doesn't go to the identity as the perpetrator. It goes to the identity as whether there was a perpetrator, but the legislator said the perpetrator. They assumed that there was a perpetrator. They didn't conceive, and thus the statute doesn't apply to those cases. The legislature created here an express lane for testing, and testing is expensive, and they wanted to limit it to those cases where you're dealing with, not where someone might be entitled to a not guilty verdict, or a case where they might have been excused, or a case where they might have been justified. They wanted to limit this particular statute to cases where the wrong person was identified as being involved in the crime.
But it's not in the legislative history, it's just in the use of the word identification in the 3 different provisions in the statute, right? That's essentially where you get that distinction, right?
The distinction between...
You're saying they're not looking for the person who's not guilty, legitimate self-defense. But the way we get there is through the language identification, right? Because as a policy matter, it's a loser for you to keep pushing, because we don't want to convict people who are innocent. So you really have to rely on the statutory language, because it doesn't sound like, and I know how careful you are, it doesn't sound like there's anything in the legislative history that's going to help us.
I mean, there are a number of legislators who discussed, they say this is access to DNA when the wrong person was convicted, and they're cited within the Commonwealth's brief. But I also think that the plain language of the statute gets you there. Material to the defendant's identity as the perpetrator.
Is there any other purpose you can think of why that language would appear? If we were to read it as Mr. Schnipper asked us to read it and just read out the identity portion?
Well, I think that sort of undoes the statute. I think that's, the court presumes that statutory language is there for a reason. If you take out that restriction, then it's every defense. And then who doesn't get testing? I mean, you either, they're.
Say who doesn't get testing, who doesn't get a Section 7 here.
Right.
It's not fair to say who doesn't get tested.
That's true. But there would be no limit to the Section 7 hearings, because there are 3 basic defenses. I wasn't there, I didn't do it, or what I did was justified, or what I did was excused or mitigated. I mean, so if you include all of the defenses, then the limiting language really has no meaning, and the legislature could have said anyone who was convicted of a criminal offense who wants to get post-conviction testing can have post-conviction testing. And they clearly didn't want to do that.
Well, I mean, you agree that the pragmatic burden on the defendant is going to be more difficult in a case like this of self-defense as opposed to somebody else did it. I mean, this is a harder case for materiality, as is the last case for materiality.
No, I agree that there is some limit there. But I would suggest that if you, again, it's still a requirement that there be some allegation that he wasn't involved.
In response to your point that this means everybody would theoretically be able to get through Section 3, I'm not accepting that. Certainly, we've talked about motion to suppress issues and necessity and diminished capacity, but what the amicus brief really has three arguments, and the first one is it would really be an absurd result that somebody who's been misidentified gets to the opportunity through testing to show that he or she is innocent. But if you just say, well, no, I didn't commit a crime, it wasn't a crime, and then you have the issue of it's a remedial statute and there's some ambiguity, and then the third reason they give is because Rule 30 is so glacial, and you have to make that prima facie showing that the legislature couldn't have possibly intended to say, okay, if you're in prison and you didn't commit the crime, you don't have access to this unless it's an identification case.
Well, and I think I think they would have a good reason for doing that, which is that in the case where a defendant has been duly convicted and sentenced to prison for a homicide, if they are given testing in a claim of self-defense, and the testing shows that they might be entitled to a not guilty verdict, then they get a new trial, and then the Commonwealth has an enormous burden to disprove self-defense beyond a reasonable doubt. So it gives quick access to people to get out of prison who the legislature probably isn't in a rush to get out, simply because the Commonwealth's burden is so high on that defense, and it's already been met once. So I think that that's the difference here, is that you're dealing with someone who might be entitled to a not guilty verdict. As opposed, if someone wasn't there, they're entitled to they get a not guilty verdict. They weren't there, they didn't have anything to do with it. If they have a justification, if they have an excuse, they might be entitled to a not guilty verdict, but I don't know that the legislature is rushing to let them out.
So basically, you're saying there's a rationale for the distinction that limited resources be used just for identification cases, and if that's what the plain language says, that's what it says.
Yes, I would agree. It's.
I'm not saying that's what I think.
No.
That's your point.
Right, no, that is. I would agree. I would agree that is my point. I see my time is up. If there are no further questions.
Thank you.
Thank you.